Okay, good morning, everyone. This is Judge Lopez. Today is February 28th. I'm going to call the 9 a.m. case of Alexander Jones, case number 22-33553, here on a couple of applications to employ. Let me go ahead and take appearances, and I'll start in the courtroom. If parties wish to make an appearance at this time, please hit 5-star. And as soon as I finish with the courtroom, I'll then turn to the phone. Thank you.
Good morning, Your Honor. Howard for the U.S. Trustee, and my colleague Jason Ruff should be in one of those boxes in front of you.
I found them.
Thank you.
Good morning. Okay, here's a 214 number.
Good morning, Your Honor. Vicki Driver on behalf of Mr. Jones, the debtor.
Okay, good morning, Ms. Driver. Here's a 202 number. All right. There's a 202, last 3 digits 960.
Sorry, Your Honor, that was me. I was on mute. I forgot to take myself off. Good morning, Jason Ruff for the U.S. Trustee's Office.
Okay, good morning. Here's a 212 number.
That might be me, Your Honor. Sarah Browner, Aiken Gump on behalf of the committee.
Good morning, Ms. Browner. Okay, a 512.
Your Honor, Steve Lemon on behalf of PQPR.
Good morning, Mr. Lemon. And here's a 210 number. Well, San Antonio.
Good morning, Your Honor. Ray Battaglia for Free Speech Systems.
Good morning, Mr. Battaglia. Okay. Mr. Driver, I got one more. I apologize. Here's an 832 number.
Jared Martin and Avi Motionberg for the Texas plaintiffs.
Good morning. Good morning. Okay, Ms. Driver, why don't I turn things over to you?
Okay, thank you, Your Honor. This morning we just have a couple of applications to employ counsel in the Texas matters. Docket number 138 is the application to employ Martin DeSeries Jefferson Wisdom LLP as appellate counsel in the Texas litigation matters. We filed that application on the 7th of February, and it was accompanied by the declaration of Mr. Martin. Mr. Martin is here if anyone has any questions for him. Just for the record, no one has reached out with any comments, concerns, or issues related to this or the other application to be employed that is up for today. Your Honor, these are made under 327E. Mr. Martin's firm is going to serve as appellate counsel. His firm is doing some work now in the post-trial issues in the Heslin matter. You may recall that via docket number 58, the stay has been lifted in that matter, and that is currently moving through post-trial motion practice, and will be moving through the appellate process and absent any other agreement by the parties.
Okay, thank you. Go ahead.
Your Honor, the rates here are just very rational rates. Mr. Martin and his partner are charging $4.25 an hour. That goes down to $195 an hour for junior associates. Paralegals are at $145. Per paragraph 13, their firm was not owed anything as of the petition date. The paragraph 13 of Mr. Martin's declaration. And so this will also help, Your Honor, Mr. Jones. This is the same counsel that FSS has employed for the same tasks in the FSS case. This will help us start to chip in on that 50% that Your Honor had expected us to pay prior to Mr. Jones' bankruptcy. Your Honor, I would ask to admit Exhibit 2, which was filed at docket number 179-2, which is Mr. Martin's declaration. Even though it is under 327E, he did run all of the same parties through his conflicts and connections system and did not have any conflicts or connections other than, of course, representing FSS in the related matters.
Okay, it's admitted.
Your Honor, I would submit that absent any objection or any other questions by Your Honor or any other party here, we just simply request that Mr. Martin's application to be employed be granted. I would note there's no deviation from the interim compensation and FIAP procedures that would apply under 330 and our interim comp procedures that were entered in this case as well.
Okay. Let me ask, does anyone wish to be heard in connection with Mr. Martin's firm's retention application? Let me just hear, I can just get a thumbs up or verbal confirmation that the trustee is okay with the proposed form of order in this application.
Yes, good morning, Your Honor. I'll take that one. Ms. Driver and I actually communicated last week, and I just confirmed to her that the form of order was satisfactory to the U.S. trustee's office, so we don't have any opposition.
Okay. So the application's at docket number 138. The court is familiar with Mr. Martin's firm and his role, as Ms. Driver alluded to, in connection with the FSS case, the related case here, and the work that Mr. Martin's firm is going to work on. I've reviewed the application. Take comfort that the trustee has reviewed it, and we had a committee at the time of the application was filed. So I take comfort with those two things. I've also done an independent review of the application, and I'm comfortable that it satisfies the requirements of Section 327E. I've reviewed the proposed form of order, and I'm going to grant the application. So where do we go next?
Your Honor, that brings us to docket number 139. This one is just very, very similar to Mr. Martin's. The only wrinkle we have here is that the Renault firm was not sitting on a retainer at the time of our filing and did request a post-petition retainer. It's a fairly modest retainer of $50,000. We did sort of recite the requirements for a post-petition retainer. We got no comments from the U.S. trustee or the committee on this issue. The Renault firm, as we've noted, is employed in the FSS case. This will allow them to continue to do what they're doing in the Heslin matter, and in the event that the Posner motion for relief filed at 113 set later this month is granted, we will obviously be needing a lot more of their help, and there will be a lot more fees associated if that motion is granted. But that is, Your Honor, one of the biggest reasons they need a retainer at this point is that in the event they are required to gear up for that trial, that's just going to be an incredibly onerous undertaking. They will be staying on once the Martin firm really takes over as most of appellate counsel, but they will be taking direction of the Martin firm, so that will alleviate any issue related to any duplication of efforts there. I do believe that the general rate is $800 per hour. They do have, I believe, an associate that does at $400 an hour, and they will as well follow all interim comp order procedures as well as the fee app procedures that are set out in 330.
Okay. Ms. Bonner, I'll start with you on this one. I want to hear, sounds like the committee's okay with this application. Is that right?
Yes, Your Honor, we are.
Okay. Mr. Ruff, same?
Yes, Your Honor. I can confirm the U.S. trustee has no opposition to this one either.
Okay. So this application was filed at docket number 139 and involves the Reynal law firm. And again, the court has some familiarity with the scope of work that the Reynal firm was retained in the FSS cases to do, and the application, the work in the application, in this case, largely mirrors that work there. So I take comfort that the committee's looked at it and that the U.S. trustee's office has also looked at it. The court has also conducted an independent review of the application, and I'm comfortable that it satisfies the requirements of Section 327E. I think the post-petition retainer is appropriate under the circumstances, and I'll approve it. I've reviewed the proposed form of order, and I'm okay with it, so I will sign the proposed form of order as well. So with that, I believe I will then turn to Ms. Browner. Ms. Browner, I believe you've got the last one.
That's right, Your Honor. Again, for the record, Sarah Browner, Aiken Gump, on behalf of the committee, I believe the only item remaining is Nardello's retention application. They are intended to serve as specialized forensic financial advisor to the UCC. The application was filed on February 6th of this year at docket number 136 with the declaration at 136-2. We filed this morning, just a few moments before the hearing, a certificate of no objection, which indicates that all parties have consented or not objected to the relief requested, including the U.S. trustee and the debtor. The court will see that as an attachment to the CNO, we filed a slightly modified proposed form of order, which reflects certain informal comments from the debtor, consistent with comments that the debtor made to Aiken Gump's retention application. And unless the court has any questions, we would simply ask that the court enter the order.
Okay. Does anyone wish to be heard in connection with this application? Okay, I do note this application was filed at docket, make sure I've got it right, at 136 to retain the UCC to retain a specialized forensic financial advisor. There have been no objections that have been filed. I did note and did get a chance to review the CNO and the modified language. Got no problem with it. I did conduct an independent review of the application, and I do find that it satisfies the requirements under the bankruptcy code, and so I'm going to sign the proposed form of order that was at docket number 181.
Thank you, Your Honor.
Okay. Mr. Driver, since I've got you here, is there anything else you wanted to talk about today?
No, Your Honor. We do expect to file one more application to employ Norm Pattis's firm for the Connecticut case. I don't know if the FSS case has done that yet. If not, Mr. Battaglia and I will coordinate and file that at the same time. But that one also is moving forward, and so we will need to have counsel to handle those issues. And that should be forthcoming. Other than that, Your Honor, we continue to work to resolve the motion for relief from stay, and we'll keep your chambers apprised if there's any movement there for that hearing coming up on the 22nd.
Okay. Anything from the committee?
Nothing further, Your Honor. Thank you.
Okay. Anyone else wish to address the court at this time? So I just had one question, and since you're here, Ms. Driver, maybe you can answer, but it's certainly something, and so it has to do with, I did see that the schedules were filed, and I did note that in a couple of places it noted that there was an appraisal to be completed, and I believe it's in Schedule AB. There were numerous trusts where the information simply listed unknown. I was wondering if you could provide me some additional color. If there is an appraisal going on, when do you expect the appraisal to be completed? And if there's any additional work that's going on to determine or what the unknown meant, I should say, with respect to the trust. I just want to make sure that I'm understanding what is meant by that word.
Thank you, Your Honor. I'm happy to elaborate. First of all, on the appraisal, we were just having a bit of trouble locating a company that would come in and do just sort of an inventory and an estate appraisal of the contents of the home. I had an associate that graciously did some searching and found someone in Austin that did give us a proposal. We're finishing up the agreement with them, and hopefully they can be down in Austin week after next, or even next week to start that. So I would expect that would be completed, mid to late of March, as well as the trust. It's quite difficult to figure out what some of these trusts own. We have done some additional. There were some amendments that we anticipate making to those that we were able to gather between when we filed the schedules and the 341 meeting, and that was to give some bank balances on some of the trusts that we were able to locate. We're also doing some what I would consider limited real estate searches, trying to find what we can online to see if there's any real estate that's located in Texas. Fortunately, with Nardello being on board, our financial advisors, Blackbriar, are going to start having weekly calls with them, and to the extent that with their resources, they have the forensic ability to find anything additional. We most certainly want to include that. There was some discussion of the fact that there needed to be sort of a fulsome round of amendments after this initial filing. And we have talked with the committee about that. I believe they'll be filing a motion that's termed a motion to compel, but we've been in communication about that and have agreed that we can provide those fulsome amendments by the 24th, and then the U.S. Trustee's Office has rescheduled the continued 341 meeting for March 30th. One of the reasons for that delay is simply that there's a spring break in there that we just lose a lot of people. Blackbriar and my office have not stopped digging, and so we continue to dig on a pretty much a daily basis, trying to locate any other assets that are owned by this trust, simply because trusts aren't really always filed of record and in some sort of official place. We've talked to no less than 6 attorneys and far more than 6 non-attorney professionals trying to locate every single trust and figure out what every single trust owns. And so we feel like we're starting to get to what I would consider the final layers of the onion.
Okay. Sounds like...
May I be heard briefly, Your Honor, in respect of Ms. Driver's comments?
Yes, absolutely. Just state your name for the record.
Thank you. Sure. Sarah Browner, Aiken Gump, on behalf of the committee. Again, just to echo what Ms. Driver said, she is correct. We've been in communication with the debtor regarding a number of concerns and blanks that we noticed in the schedules and statements. We've also been in touch with the United States trustee. We reached out to your chambers this morning and left a message just to try to get some time on your calendar. We conferred with both the U.S. trustee and the debtor and proposed, subject to the court's availability, perhaps a very brief hearing on the 8th to discuss a motion that, as Ms. Driver mentioned, is forthcoming. It is styled as a motion to compel, simply to set a deadline by which the amended schedules and statements will be filed, and some bells and whistles around that in terms of disclosures that will be required to be made. So if the court is amenable, we would request just a brief hearing on the 8th, or as soon thereafter as the court can see us, to discuss the motion that should be filed in the next couple of days.
Yeah, again, without seeing it, but I do have time, probably the afternoon of the 8th. If anyone's
Sure.
just looking at my calendar, but again, please confirm with my case manager, because she'll know of other things that I probably said yes to that she'll know for sure a time that works. But it's from what I can tell, from 1 o'clock onwards, and I'm sure after this hearing you'll hear from someone or shortly thereafter. Okay.
Of course, Your Honor.
All righty.
Thank you.
So it sounds like things are progressing on that end, and I appreciate the additional clarifications. All righty. Anything else we need to talk about today?
Not from my perspective, Your Honor. Thank you.
All righty, folks. Thank you very much. Have a good day. Thank you.
Yeah.